we continue to keep our focus on that crucial judgment that came from the Supreme Court of India today. Let's cut across to this breaking bit of information that we are getting for you. The order copy is out. The judgment copy is out. It's a 366-page long judgment. And as the Chief Justice of India had reiterated in the open court pronouncement of the judgment today, that 4 separate opinions are there. On the majority of the issues, the court is unanimous. The moot point being that marriage is not a fundamental right. On certain aspects which pertain to the recognition of civil partnership and also the right to adopt for same-sex couples, it's a 3:2. Well, I want to take you through this part of the judgment, which is largely about what the Chief Justice of India has said. CJI on various points, especially on the adoption and the recognition of civil partnership, is in the minority. But many legal experts have argued that for the times to come, this particular part of the judgment will be much talked about because this is a forward-looking one. Well, in this part, you can see the court has argued that it is vested with the authority to hear this case under Article 32. The court has also said that it has the power to issue direction, orders and writs. Let's come to the other part. These are 3 cases that were cited very often by all the judges today. It includes just case Puttaswamy, the 9-judge case that laid the law of the land in this country, that privacy is a fundamental right. In Shakti Vahini, of course, in Shafeen Jahan is another important case. This is the Hadia case that we're talking about. The Constitution does not expressly recognize the right to marry. An institution cannot be elevated to the realm of a fundamental right based on the content accorded to it by law. However, several facets of the marital relationship are reflection of constitutional values. If you look at the 4 separate opinions that have come out, the most liberal, forward-looking interpretation has been given by the Chief Justice of India, Justice D.Y. Chandrachud. But even the CJI, in his opinion, does not believe that marriage is a fundamental right. It's a statutory right at best. Statutory rights cannot be enforced by the court. It's only the constitutional rights or fundamental rights that can be enforced. Let me cut across to my colleague Ananya Bhatnagar and get more details. Ananya, it's a long judgment. We all will have to spend some hours reading it threadbare, but any particular portion that you want to take the viewers through?
Definitely, Anusha, it is a judgment that runs into almost 366 pages with 4 judges giving out their opinion. But if I take you to page number 81 of the judgment, where a very interesting aspect has been discussed by the chief, and it starts by, is queerness an Indian concept? Who is an Indian? And what practices are Indian? So he starts on by saying that queerness is a natural phenomenon which is known to India since ancient time. The question of whether homosexuality or queerness is unnatural is no longer a recent tikra. In view of the decision of Navteej Singh Johar, where the Supreme Court held that it is innate and natural, the contention of the Union of India that heterosexual unions precede law while homosexual unions do not and cannot be accepted, in view of the decision of Navteej Singh Johar, where this court held that queer love has flourished in India since ancient times. He further goes on to say that with respect to sex and negotiating Hijra identity in South India, he also goes on to cite various books and judgments, and a very important part comes at point 84, which is at page 82. Goes on to say that like English language, some English words employed to describe queer identities may have originated in the other countries. However, gender queerness, transgenderism, homosexuality and queer sexual orientations are natural, age-old phenomena which have historically been present in India. They have not been imported from the West. Moreover, if queerness is natural, which it is by the definition impossible for it to be borrowed from another culture or be an initiation of any other culture, is what the Chief Justice of India has gone on to say.
Right. Thank you. Thank you, Ananya, for bringing us those bits and portions of the judgment. And it's a treat. We must read that judgment. It's going to be quoted, cited, debated upon in the times to come. The dust has not settled for good. That's a given.